How's your mom doing?
She's doing well.
Yeah.
I've seen a little bit more of me, which I don't know if that makes her feel better or worse. But yeah, I mean, there's some things that I tell her.
All right, welcome to the Trademarks in Cyberspace panel. My name is Irina, Manta. I'm going to be introducing our distinguished speakers today. First, we're going to start with Professor Stacey Dogan, who's a professor at Boston University School of Law. She came there from the Northwestern University School of Law, and she writes in areas of intellectual property and competition law and has published in journals such as the Stanford Law Review, Emory Law Review, and others. Then we have Professor Graeme Dinwoodie, who's the Professor of Intellectual Property and Information Technology and Director of the Oxford Intellectual Property Research Center at Oxford University School of Law. He came there from the Chicago-Kent College of Law. He is the author of 4 case books and a number of leading of articles in leading law reviews. And then, last but not least, we have Professor Olufunmilayo Arewa, who teaches at the Northwestern University School of Law, where she came from Case Western. She writes and publishes in the areas of copyright and music, accounting, corporate and securities law, strategic uses of intellectual property, and other areas. So with that, let's welcome our guests.
4 case books. That's a little intimidating. I'm glad I'm going first. So thanks to Case Western and to Jackie and Ray and for the invitation. I'm happy to be here. In many ways, I think I'm going to follow on and hopefully build a bit on Corinne's presentation. One of the big themes of her talk, as I understood it, is this idea of trademark holders turning to intermediaries and using intermediaries to clamp down on legitimate uses of their trademarks online. I've been for several years now, partly with Mark Lemley and partly on my own, exploring some of these similar themes, but in a somewhat different context. Most of the work has been relating to this question of trademarks as used in keywords to generate advertisements on search engines. And in this context, for the last several years, this question of so-called trademark use has taken center stage in recent years on the debate over intermediary liability for infringement that occurs or allegedly occurs using search engines. Scholars and courts and trademark holders and advocacy organizations have all wrangled over whether a so-called trademark use doctrine does or should play a gatekeeping role in these intermediary suits. And just to make things concrete, the trademark use doctrine, as I unsuccessfully suggested and proposed, would essentially provide a threshold question for the court and say, does this particular defendant use the trademark as a brand for its own products and services? Right. If so, then it can potentially be liable for committing direct trademark infringement. Right. If not, it could potentially be liable, but under theories of indirect liability. So this doctrine, this non-existent and at this point completely discredited doctrine, was the subject of significant scholarly debate, and for at least a little while was emerging in some of the cases, and it's been kind of slapped down over the last several months. So doctrinally, the debate addresses whether the Lanham Act places any limit on the types of use that use of trademarks that can subject one to a claim of direct trademark infringement. The real conflict, though, in the cases and in the literature, Graeme and I have been fighting about this for years, the real conflict is at a normative level, right? Whatever the Lanham Act says or does not say about trademark use, should trademark law limit the definition of direct trademark infringement to situations in which the defendant has used the mark as a brand for its own products and services. As I said, the issue has arisen most recently in a number of search engine cases in which mostly Google and a couple of other search engines have been accused of committing trademark infringement by allowing advertisers to purchase trademarks as keywords to generate advertisements for their products and services. So if you search for Mercedes on Google, right, BMW places an ad that is not in the search results, but alongside the search results. And the question is whether Google has or can commit direct trademark infringement through selling this trademark as a keyword to generate these ads. There are obviously a number of excuse me. I had to wake up really early this morning, so forgive me if I have some mental burps during. There was a fair amount of uncertainty in some of the early cases as to whether the courts would treat these intermediaries, these search engines, as potentially directly liable or not. In many jurisdictions, the courts said, the Lanham Act doesn't really differentiate between different kinds of uses of marks that can subject someone to trademark liability. And therefore, if there's any confusion, the search engine has used the mark, and therefore it could be on the hook for liability. A number of district court opinions in the Second Circuit, which looked to a Second Circuit decision involving pop-up advertisements, concluded that the Second Circuit had a threshold trademark use doctrine that limited the liability of intermediaries in these contexts. And there was a case in particular involving Google and RescueCom that said Google can't be liable as an infringer for selling trademarks as keywords to generate ads because it hasn't engaged in so-called trademark use. Earlier this year, the Second Circuit put this doctrine to rest and said, no, there is no such doctrine in our jurisdiction, that any use of a mark in commerce that facilitates consumer confusion can constitute infringement under the Lanham Act. Now, the court was fairly nonspecific about what it meant by confusion and where the nexus lay between the specific use at issue, the sale of the keyword, and the confusion of consumers, but it gave some hints, which I'll talk about in a few minutes, about what its concerns were. The case was involved a rejection of a motion to dismiss, so the facts are not well developed and will have to be developed by the district court upon remand. So it looks like the trademark use doctrine, much to my great dismay, is out, my greatest failure in life so far. But there's continuing uncertainty about a number of issues, and I want to just raise three of them. Number one, what kinds of acts by the intermediaries can justify a finding of infringement against them? Is it the mere sale of a keyword, of a trademark as a keyword to generate an ad, or is it something more, right? Number two, on what doctrinal basis, right? How does the behavior match up with trademark doctrine? And in these cases, are the courts going to find liability based on direct trademark infringement, or are they going to try to incorporate at least some of the principles that have been discussed in the literature on the distinction between direct and contributory infringement claims? And then finally, and I think this is a really important point that has not yet been explored in the courts and in the literature, what remedies are going to be imposed, right? I will explore each of those three questions over the next few minutes. My claim, my basic claim, is that courts really need to use greater precision in defining the nexus between the defendant's behavior and the particular harm at issue in these cases. If they do so, and I hope as they do so, we will see an increasing distinction between what I like to think of as direct infringement claims and what I like to think of as contributory infringement claims, whether or not the courts actually label them as such. And this attention to detail and this precision needs to extend not only to the doctrinal analysis of liability, but also to the remedies that courts impose in these cases. Remedies need to be narrowly tailored to the defendant's own behavior that's causing the harm at issue. And importantly, courts need to pay attention to the public interest in access to information using marks. All right, let me just step back for a minute and give a little bit of background. For those of you who have heard me give any talk on trademark law before, you may go to sleep for the next 5 minutes because this is just, the standard stuff. There are some competing views of why we have trademark protection in the first place. Graeme and I somewhat disagree on the normative basis of trademark law, but the model that I like, and the one which conveniently the Supreme Court seems to like, is an economic one. Sorry. Trademark laws exist not as an exception to the competitive model, but in order to promote competition in markets, right? Trademarks provide a convenient shorthand through which producers and consumers can communicate with one another, and we protect them for that reason. They reduce the cost of information transactions, and they thereby promote more competitive markets. So unlike patent law and unlike copyright law, trademark law is not a departure from the competitive model. It's actually supposed to be a facilitator of competitive markets. Informative, non-confusing uses of trademarks, even ones that are not authorized by the trademark holder, ought to be allowed, and they are allowed, right? So resellers of the trademark holder's products, whether they're authorized or unauthorized resellers, are allowed to use the trademark to describe their products. Sellers of complementary products are allowed to use the trademark to describe their products. And importantly, competitors can use the trademark to call attention to their products. The Coke-Pepsi challenge, my students are now too young to remember the Coke-Pepsi challenge, but it looks like at least some of you in the audience might remember it. That was a classic example of a competitor seeking to free ride on the fame of an established trademark to call attention to its competing product. No confusion, no infringement, right? So under this economic model, there are all sorts of uses of trademarks that are not only legitimate, but that actually promote the goals of trademark law, even if they are not authorized by the trademark holder. And even under competing approaches to trademark law, the more loosey-goosey, unfair competition approaches to trademark law, at least some of these uses are allowed, right? So whatever model you pick for trademark protection, for the normative foundations of trademark law, everyone agrees that there are some legitimate uses of trademarks by competitors and other third parties. All right, so as applied in the online context, and particularly in the case of intermediaries, there are some important implications of this model and of these rules. Right? There are all sorts of parties who have a legitimate interest in using trademarks online. Corinne has talked about some of these. Eric Goldman, I've heard his talk 100 times too, talks about others. His favorite example is a camera, right? I've got a Nikon D70. We can think of scores of different parties who might have an interest in the fact that I'm searching for information on a Nikon D70 and might think that as a result of me conveying that information to the search engine, right, I am identifying myself as a potential consumer of products that they're offering, right? Camera stores, camera magazines, photo magazines, lens sellers, sellers of complementary products and sellers of competing products, right? So all of these uses of trademarks online by competitors and others are legitimate and actually important to promoting trademark law's goals. Intermediaries have an important role to play in helping these people to reach their potential customers. And the use of trademarks as keywords to generate advertisements is an important, provides an important step in allowing these advertisers to reach their potential customers. Of course, trademark holders don't like this, right? Especially when a competitor buys their trademark as a keyword and generates and places an ad based on it. Trademark holders complain and in many cases file a lawsuit. And their lawsuits claim a couple different things. Sometimes they sue the advertiser. But in the cases that I'm interested in here, they sue the search engine. And they say that because you have allowed my competitor to purchase advertisements keyed to my trademark as a keyword, you have committed trademark infringement. Now, there are three different species of these claims that have been made, could be made, and are likely to confront the court in the courts in the coming years. And I've divided them into three different labels. Number one are what I call general confusion claims. These are claims that the RescueCom Second Circuit Court seems to have been concerned with, and that I think the Ninth Circuit in the Playboy Netscape case a number of years ago seems to have been concerned with. These general confusion claims are claims that the intermediary itself, through the physical placement of advertisements as compared to search results, is creating confusion about the distinction between search results and ads. Right? This is a complaint about the integrity of the search engine's informational services. The second kind of claim, or potential claim, are strict liability claims. These claims would argue that because the search engine has used the trademark in a way that ultimately generates an ad, it is automatically on the hook for any confusion that might result, right, from those ads. So these claims would attempt to hold the intermediary liable, even without any direct causal relationship or proximate causal relationship between its own behavior, right, and the resulting confusion. It would hold the search engine liable even if it was misinformation or misstatements that were made by its advertisers. And then the third species of claim that I'm interested in are failure to act claims. These are claims that are based on confusing ads, but that turn on the search engine's failure to respond to notifications, kind of a notice and takedown type approach that would turn on the intermediary's failure to respond to complaints of infringement by advertisers who have placed keyword-based ads. The courts so far, though of course the plaintiffs like all of these claims, the courts so far seem most interested in the first and potentially the third. And my claim is that as these cases make their way through the courts, and in particular through the district courts, the courts need to be very careful about each of these theories of liability and to develop doctrines that are specifically tailored to these different, the really different nature of these claims. All right, let's start with general confusion claims. My starting point is that I actually don't think these claims are trademark issues. I think these are that trademark law is actually under-inclusive in addressing the harms from search engines mislabeling the search results and confusing the difference between search results and ads. But you know, the case law seems to be going the other way. The Second Circuit really seems to think that it is a trademark issue if search engines allow trademark-based keyword advertising that is not carefully differentiated from search results. So I'll accept that. Even accepting that, it is very important for courts to keep in mind that this is the basis, this sort of general creation of confusion is the basis for a finding of liability, and to tailor their remedy to the acts by the search engine that are allegedly causing confusion. So if the problem is that ads are not sufficiently well differentiated from search results, then the remedy needs to be to an injunction requiring the search engine more carefully to label its ads. That's it. Right? The remedy shouldn't go further and say, and furthermore, you know, you shouldn't use keywords in any of these other contexts. The second type of claim, strict liability claims. Courts should reject these. There is no proximate causal nexus in these cases between the so-called use by the intermediary, the mere sale of a keyword, and confusion created by particular individual ads. There is but-for causation, right? You have certainly enabled your advertiser to place a deceptive ad, right? But the search engine's own behavior is neutral behavior that facilitates both confusing and legitimate uses. Right, so the nexus between the search engine's behavior and any confusion that results is too attenuated to result in liability in these cases, I would argue. And the nature of these claims, whatever they're labeled, is really one of contributory infringement, right? The claim here is really an advertiser is creating confusion, and the search engine, through the sale of this keyword, has helped to facilitate that confusion. The doctrine of contributory liability in the trademark context is woefully underdeveloped, but we can hope that the courts develop it in the coming years. And I think it's important when they do so that they engage in some of the same analysis that courts have done in copyright cases. There's an analogy in the copyright context, the Sony substantial non-infringing use doctrine, whatever it means, but it's got to mean something, right? When we're thinking about behavior that facilitates both infringing and non-infringing uses, we need to be sensitive to those non-infringing uses, right? And not find liability as long as the intermediary in this case has really important pro-informational functions. I know I'm out of time, so let me just get to the third category, these failure to act claims. This is a category of claim that really has not been fleshed out in the search engine cases. It has recently been fleshed out by a district court in New York in the Tiffany case, which is up on appeal to the Second Circuit right now. But the basic nature of these claims is that when an intermediary with knowledge that someone is using its service to infringe allows that party to continue to use its service, it can be held liable for contributory infringement. I think these are perfectly plausible claims, and I actually think this is where a lot of the action ought to be. Eric's groaning. Ought to be in these. See, I'm actually a middle of the roader, it turns out. Ought to be in these cases. There are really important and difficult questions that the courts need to resolve about the nature of knowledge. What is knowledge that someone is using your service to infringe? I think courts need to be protective of intermediaries on two different levels on this point. Right? Number one, they need to protect against the use of general knowledge as a proxy for actual knowledge. The fact that a search engine knows that maybe someone someday might use these advertisements as an opportunity to infringe shouldn't be enough, right? But number two, given the fact that there are so many legitimate uses of trademarks and that it's sometimes difficult to determine whether a use is a fair use or not, courts need to be generous to defendants in allowing them some scope of reasonableness in saying, yeah, I got a notification of infringement, but I reasonably concluded that this defendant was protected by fair use and this ad was not confusing. With that protection, I am comfortable saying that if there's an obvious act of infringement taking place by an advertiser and the intermediary is notified by the trademark holder of that infringement and fails to take action, that contributory liability might be appropriate. And again, I think it's important that courts be careful in structuring injunctive relief in these cases to avoid collateral damage to legitimate uses of marks. All right, I have more to say, but I am way out of time, so thank you.
All right. Well, again, let me echo what others have already said. To thank Case and Jackie in particular for the invitation to come talk. And listening to Stacy, having debated Stacy for what seems like many years now, on trademark use. I'm sort of tempted to just throw away my PowerPoint and respond, if only because, in fact, well, we'll get to some of that maybe in the Q&A. If only perhaps I actually agree with large part with where Stacy has moved to on these issues. Because,
I haven't moved
because in fact, I think, to pick the title of her paper, I think we have moved beyond trademark use into a lot of the issues that Stacey is talking about, and I think that's the helpful is the right locus of debate now, the kind of factual issues that Stacey raises, and in fact, I found the three species of actions that she talks about actually very useful, and you'll see when I'm focused mostly on the EU developments, that in fact some of these factual sort of thin slicing is beginning to happen, I think, in the EU. So I think we're probably not as far apart as you think on that. So let me say what I was really going to talk about, and what I'm going to try and focus on, and maybe try and incorporate some reactions, if I can, to Stacey's remarks, are three cases that were joined and decided recently by, I say decided, at least the opinion of the Advocate General in the European Court of Justice, Maduro, was handed down on September 22nd, and we expect a court opinion sometime early next year. However, this is the tip of the iceberg in Europe, in that there actually are 10 cases currently before the European Court of Justice on reference. So think of that, that's the equivalent of 10 cases before the US Supreme Court on the issue of keyword advertising. And the national courts are still deciding cases on a daily and monthly basis, sometimes without any regard for the fact that their issue is already going up to the ECJ. So there is a huge amount of activity in Europe. And what's interesting about this, if you take the headline story of the ECJ's opinion or the Advocate General's opinion in Google, it's surprising. I think most people, and you saw this in Google's different policies in continental Europe on the one hand, and the United States on the other, would have thought that in fact the trademark owners would conventionally understood have greater protections in Europe than in the United States. But if you read RescueCom and then you read Google from the ECJ, you sort of think, well, this is sort of the wrong way around. So it's intriguing that they've got to where they've got, and I want to try and explain a little bit about why they're doing that. And the first thing I want to emphasize is these are three cases that went up, but they're all slightly different cases. So they decided them, and they sort of there was a composite of the questions. But there are three different cases which have different factual variables. I want to mention the three that are in this reference, but also talk a little bit about the other factual differences that come through in the other pending references. So the first case, and the one that I think was most favorable probably to the trademark owner, was the Louis Vuitton case. And why that potentially was the most favorable is you had two facts that didn't exist with respect to the other references. One is that we were dealing with a mark with a reputation, which is the EU lingo for famous marks that get dilution protection, which implicates a series of other protections, obviously. And secondly, the advertisers were alleged to be counterfeiters, and that potentially implicates another set of values that the court wants to take into account. The second case is probably the weakest one, where we had a truly descriptive mark. It reminds me of the American blind type litigation in the United States. And no reputation, and you could see huge numbers of very legitimate descriptive uses of that mark in keyword advertising, and I think if that had gone back down on a separate sort of finely grained analysis, you could see that being a very unfavorable context for trademark owners. The third one, very similar, the Tiger case, which I'm not going to talk much about, but it also raised the question of advertiser, the purchaser liability as opposed to the search engine, which again raises a different set of issues about whether that's the appropriate defendant rather than, in fact, the intermediary. I know it here, but I want to talk a little bit about this one, maybe if we get into questions about Stacey's paper, that in fact, if you look at the other pending references, what's intriguing about these references is how much factual detail you can find in the references. It just looks odd for national courts to be referring cases that really are, questions are really, please decide this case if the following 25 facts exist for us, which is not the normal procedure you expect in reference. You expect legal questions to go up. And there'll be a reason for that I'll come to in a second. Let me just mention some of the things that the national courts from Holland, from Austria, from Britain, from France, from Germany, have all mentioned in the questions, because I think they indicate some of the factual variables that they think might change the outcome. So is there differentiation between sponsored ads and organic results? Is that a clear differentiation? Is there labeling? Clear labeling of sponsored ads, which gets to the remedies question I think Stacey quite rightly points to. who exactly are the defenders? Are they legitimate resellers, basically, within the European Union, to whom we should be essentially giving some freedom? Or, in fact, are we talking about counterfeiters that are essentially using this particular mark? To what extent has the search engine been suggesting particular terms? So in the Louis Vuitton case, the allegation was that the Google suggestion tool was suggesting to the advertiser that it should use fake Louis Vuitton or imitation Louis Vuitton or buy replica Louis Vuitton as the keywords rather than just Louis Vuitton. And this last one that I mentioned, because again I think it's very interesting and it gets to a question that Eric and Stacy were going to disagree on a little bit, is what is the relevance of the policy of the search engine? And I thought that was an odd question to have asked up in the interpretation of the directive, but I think where they're ultimately nudging towards a little bit is what are the different conditions that might construct a notice and takedown system, right? And if you go back to looking at where we got in the copyright context, it didn't just come from the DMCA. The notice and takedown system came from courts initially working out in the context of discrete cases what were the different variables that put you on one side or the other side of a notice and takedown immunity. And I think you see some of that beginning to come up in all these very detailed pending references to the ECJ. All right, so this is a sort of mixed picture at the moment, still a little bit unsettled. Let me quickly run through the structure in the EU so that you can get some of the shorthand that I'm going to try and use. Their structure of trademark and unfair competition law is not unlike the United States in the sense there is a direct trademark infringement liability, but one little variable is important to recognize is that there is a set of cases for all marks in which there is a form of protection that doesn't require you to prove confusion. It's what's Article 5.1a of the Trademark Directive. It's called a double identity case where you use the same mark on the same goods. In that circumstance, you don't require to prove confusion. That's actually proved to be a problematic provision for the European Court of Justice. Another important distinction is they do have dilution. They don't call it dilution, but it is dilution, Article 5.2 of the directive. But they have a broader component in there, at least have had for the last 4 months now, as a result of the L'Oreal Ballure case, which is a comparative advertising case in which the court articulated what I can only read as INS redux 90 years later on misappropriation. And if you read that paragraph in L'Oreal, you couldn't possibly think the Advocate General could have written this opinion, because L'Oreal basically endorsed a misappropriation theory of unfair competition under the dilution rubric in European law. A lot of people, I think including myself, don't like that decision, but it is the more recent decision on dilution from the court. There is also behind that, in theory, in some countries, secondary liability theory. It is not as uniform as you'll see throughout Europe, however. It is litigated under a series of different tort doctrines in different countries, and it is not harmonized, which is a very important point that we'll come to. And finally, there are behind this unfair competition law claims under general tort principles, fault principles, which again is unharmonized. So this is the structure that we're dealing with and that the court has to consider. The questions that the court brought together from the 3 references from the court from the French court were as follows. First of all, were the search engines liable for the sale and display of the keyword advertising under Article 5.1, which is both the 1A, double identity provision, and 1B, which is confusion? Secondly, were they liable basically for dilution? Which is the second question. The third one looks really weird, and it looks really weird for significant reasons, which is basically the way it's phrased is Google liable under 5.1? Is Google liable under 5.2? If they're not liable under either of those, are they immune? And you're thinking, that doesn't make any logical sense, all right? Why are you asking this third question? In fact, the Advocate General takes some pains to say, the parties disagreed what this meant. It's like, is the not meant to be there? Is the French doesn't translate well? I mean, what is it that's going on here? And the answer is that the third question has nothing to do with trademark liability. It's to do with the unfair competition liability that might exist at the national law level. So, in fact, the big question for Google in practical terms, if it wants a European-wide policy, was in fact the third one. It won the first two on the trademark question, but it wanted immunity under the e-commerce directive because that would have trumped national unfair competition laws. So, in fact, the third question, which looks really weird, is in fact a very significant one that I'll get to in a minute. The fourth one they didn't spend much time on. They took it as essentially derivative, which is an interesting way of thinking of it. You'll see the Advocate General concludes that the search engine needs to be able to do this, and for the search engine to be able to do it, people need to be able to buy the keywords. Therefore, the advertisers can't be liable. All right. So, let me go through the detail of his opinion. First, one important, very general argument that Dogan made that in many ways was the nuclear weapon of an argument but was rejected, was simply said, look, this isn't involving use of trademarks that come within the directive because we're not using a sign. This is in many ways a parallel and analog to a trademark use argument, which is we're using the mark in some way that doesn't really come within the scope of trademark law. And what was interesting about Maduro, even though he ultimately comes down with an opinion that's very favorable to Google, he says, no, we have to evolve, right? The notion of sign is not static. The fact that this is not the way trademark infringement would have occurred in 1920 doesn't mean that it can't be the way that trademark infringement can occur now. And I think that's important, all right? Because in fact, one of the arguments you heard in the American context on trademark use has been, well, look, 99.9% of cases were trademark use cases, therefore that defines the universe of trademark infringement. And Maduro, even though he comes out with a pro-defendant decision, actually rejects that argument, which I find interesting. He did something also interesting, which I think the American cases have not done well. Stacy does very well in her paper, which is he distinguishes between different activities of the search engine. So he says, well, they're engaging in sale, right, when they're selling the advertising to the advertiser, and then they have this separate set of activities on displays of sponsored links. And he said, the reason that I'm going to separate those is when you look at the conditions for 5.1b liability, which, to put it in American terms, would be the confusion-based cause of action, there is a need that the use relates to goods or services which are similar to those covered by the marks. Well, with respect to the sale, that isn't true, he says, because Google is selling advertising services, and that is not a similar service to handbags, right, Louis Vuitton, and therefore that is not satisfied. We don't have the similarity of goods or services, and so the sale case ends right there under 5.1b. And so all I need to worry about now is the display case, whether they were doing something in displaying the ads that gives rise to liability. So very, very careful parsing of the different search engine activity, which I think is exactly the kind of approach that Stacy in many ways is endorsing. So the element that's left to prove in the display case is what is in EU speak the essential function. Has it been undermined, the essential function of the trademark in the context of display? And what that question normally translates to is there been confusion, to put it again in American language. And again, he stresses something important here that I think is something really key, a parallel also in the American cases. You see this, I think, even in the eBay decision of the Southern District in New York, which is that he's addressing keywords as the trigger. He's saying, I'm looking at this question completely independently of the content that's actually in the ad. This is simply using as a trigger. He's therefore not deciding the questions of the relevance of stuff that comes up in the content. And he starts with a proposition that I think is astounding to see in a European Court of Justice opinion. I actually love the elegance of this. He retired from his position 5 days after he wrote this opinion to go become a law professor at Florence. So it's an interesting, it's like a final farewell. He said, whatever result I reach, I don't want Google to be on the hook for organic results. Whatever happens on this left-hand side has to still happen, and I cannot come to a conclusion on the right-hand side that screws them on the left. Right? Now, it's not unusual maybe to see that in common law opinions, but I thought that unusual from a Portuguese lawyer, maybe, as I say, his last hurrah, and maybe one that the court might not entirely agree with. But anyway, he starts there as the sort of starting point. He wants to make sure, as a policy matter, that there's nothing he says that can end up with people basically able to stop the organic results operating the way he thinks they should. So he says, what about this essential function? What would interfere with the essential function? He says, well, it has to produce an association. The display has to produce an association between the competitor who's purchased the ad and the proprietor of the mark without regard to what's in the content. So back to the question of a trigger only. And he says, well, that's normally a question for national courts. What is confusion, right? These are factual questions, and factual questions go to the national courts. He says, however, if something is so blindingly obvious to us up here, we should be able to say to the national court, this, as almost a summary judgment matter, is a question that you have to resolve in a particular way. And he says, this is blindingly obvious to me, that in fact, without regard to the content of the ad, there will be no confusion that you think that just because something pops up in a sponsored link is some ways associated with the search term that you put in. He said, this is essentially obvious to me, and therefore there will be no confusion, there will be no interference with essential function, there cannot be a cause of action under 5.1b. And interesting, I mean, that you can see national courts have reached this decision. The British courts in the Reed case about 6 years ago basically said this is a matter of summary judgment. The German courts about a year ago did it in the context of company names. So it's not a radical conclusion. I think you can see it to some extent even in American cases where we've had verdicts for defendants at trial or summary judgment for defendants in particular contexts of district courts. What is interesting is that it's rare that the court has done this. If they follow what the Advocate General suggests. But there are a couple of other instances where they have done it. And the most notable one is another trademark use case. But a trademark use case that's the flip side of this debate, which is Arsenal, which is a case involving merchandising as to whether or not a soccer club could control and prevent unauthorized uses. And there, basically, the court essentially said to the British courts, interesting factual findings about why people wear red and white scarves on a Saturday in London. But you don't understand, this is trademark infringement, all right? And the British courts initially rebelled against Mr. Justice Laddie. The late Mr. Justice Laddie said, no, that's a finding of fact, I'm going to ignore you. It's for the British courts to decide questions of fact. And the Court of Appeal gently said, well, maybe you're right, and maybe that's not what they should have done, but basically this is confusion, all right? So in some ways, this is the summary judgment for defendants, parallel to what Arsenal was as the summary judgment for plaintiffs in the merchandising context. And I say compare Adam Opal, which is the trademark use in between, case in between, which was about 4 years ago, where the court said, well, there is a trademark use doctrine, but really it depends on whether there's confusion, and they sent it back to the national courts. Here they say, we are going to make an EU-wide decision, essentially, on whether or not there is a cause of action. All right, so as a matter of 5.1b, on the confusion-based cause of action, the Advocate General essentially says no cause of action. However, he has a problem, which is that 5.1b is not, it's the weakest of all the rights under European law. There are two other provisions, 5.1a, which is the double identity provision, and 5.2, which is dilution. And these are intended, and much more explicitly than I think American law has ever done, but, and here's where I disagree a little bit with Stacy, I think, in fact, American law frequently does protect other than, in fact, source and search cost issues and functions. European law is quite explicit about that in 5.2. And the L'Oreal case, this sort of, Trojan horse, in L'Oreal basically extended, you could argue, extended dilution protection almost to every mark in the double identity context in 5.1a. So he has to get around. He can't say no confusion, therefore defendant wins when he's dealing with a 5.1a or 5.2 cause of action. So how does he get around that? He gets around it a slightly different way from the way he got around it in the first 5.1b context. He said, look, this is not absolute protection. We can't give absolute control of marks. And when I look at case law throughout Europe, I see many other values involved in trademark cases. And he lists the obvious ones, but it's good that he listed them, and we should do more of listing them. Freedom of expression, freedom of commerce, Article 6, which is the EU very stingy version of fair use. Comparative advertising, which arguably the L'Oreal court just ran a horse and cart through, but in theory it's there. And then fundamental rights, he actually cites European Convention on Human Rights cases and says there are some values that need to be protected. So he lists all these, and he says, well, actually, to be fair, none of them actually apply. However, he did something very interesting, and which I've argued for a long time we need to be doing in the context of defenses, which is he says, well, when you look at all of these, they don't actually apply, but what they suggest is there's a series of values that are validated, corroborated by trademark law. And when we look at those values, in fact, the values to serve those values here require that we find for Google. Because in fact, it's almost like an under-included, lesser-included offense, all right? He says, look, this is actually less intrusive than any of the things that would get you off. So even though it doesn't strictly fall within the terms, because it's less intrusive, I'm going to give him the break. And moreover, he does something else which I think is really important, which I think needs to be an important part of what trademark law does. He starts providing affirmative reasons why the unauthorized third-party use is valuable. He doesn't rely, as I think the trademark use advocates relied on too much, saying there's no harm. He almost goes so far as to say, well, maybe even there is a little bit of harm, but even if there is some harm, I don't care. There are socially useful uses that this is occurring through use of keywords, and given that there's not much on the harm side at all, and there's a lot on the plus side, then in fact I'm going to fine for the defendant in this instance. All right. Now I think this is basically a policy decision. If you read his opinion, he's very concerned about the slippery slope that leads to basically search engines being shut down, given how valuable they are. But I just want to point out that he's basically validated what Google does in two different ways. The first is that he's used policing of factual determinations in the context of 51B. And here he's basically used legal rules. Right? So there's two different ways that you can restrain the expansion of trademark law if you think it's going too far. One is, in fact, by simply not turning the whole game over to sort of paternalistic notions of confusion determined at the trial level. The other one is actually through legal rules. All right, but then he quickly gets, and this gets me to Stacy, and I'm going to be careful with my time, secondary liability. And as Stacy said, I think this is really where the search engines want the game to be played in the United States. But he says this is not part of EU trademark law. And he actually does quite an extensive discussion of Dinwoodie and the American case law. He said, I don't want to touch that. I think that's harmful. He thinks, would you believe, and though I find this hard to believe, he thinks the standard is actually too easy to satisfy, but he thinks that's the case. So he said, we don't have secondary liability. However, it may exist as a matter of national law. He says you actually might be able to prove national unfair competition rules actually allow you a cause of action for secondary liability. Now, that's a real problem. But if he's just said this stuff has to be something that the search engines can do as a matter of fulfilling a number of European values, it seems to me very odd to then say you can go back to 27 different national unfair competition laws and interfere with it, according to a series of rules that are completely all over the place. That question has been referred about the conflict between the national unfair competition rule and the European level in the two cases, Interflora from Mr. Justice Arnold in the UK and Portakabin from Holland. That therefore makes the e-commerce directive question really important, because if they could prove immunity under European law under the e-commerce directive, then in fact you don't have that problem. And he says they're okay with respect to the organic results. You can see where he started, you can see where he's going to finish. All right? He said the organic results, they're okay. Article 14, the hosting provision, which sort of is the IP-wide version of the DMCA, protects them, but there's a principle of neutrality in that hosting provision, which is you get immunity if you haven't done anything in some ways to influence the content. He said AdWords is not a neutral information vehicle, it's paid, which may be a very European notion of interference when the market gets involved, all right? But he says the result, it doesn't protect them on those questions. All right, last couple of points, so I see I'm getting close to time. He does say, I then have to consider, because of the Tiger case, whether the advertiser should be liable. He really says, here, it's almost derivative of the search engine liability, which is interesting because that's a real inversion in some respects of the kind of normal and I think American way of thinking, the order we think through the analysis. And if you want to get completely crazy, if you read the Interflora decision, which is the British reference to Mr. Justice Arnold, there's allegations in there that the advertiser is an accessory to Google's direct liability, which is, and you start seeing all these different cross currents. So quite the order in which we should be thinking about these, I think the European Court, in the Maduro opinion, hasn't quite gotten to. Will he be upheld? No, is my prediction. Now, normally you can't say that in the European Union. The Advocate General is upheld 85% of the time. However, in the last three most significant trademark cases, including one last week, the Advocate General was reversed, and I think he will be reversed too. The cases, just for your reference, if you want to sort of compare them, are O2, L'Oreal, and Pago. And the reasons why is I'm intrigued by whether they're going to feel like they can make the factual determinations at this stage. Now, obviously, they showed in Arsenal they're willing in some circumstances to do it. I'm not so sure that the Court of Justice has shown a defendant bias towards doing that. I think it may have a much more pro-trademark winner bias towards doing that. In particular, I don't think the type of balancing that I thought is wonderful in his opinion, when he really does go through all the social values that are at play, it just doesn't, it's not, you read an ECJ opinion, they don't read like that. Now, he's in a better position. He just has to convince himself of the truth of what he's saying. ECJ opinions are complex because you have to convince the other judges and then write one opinion, because they don't have dissents. So that's why you get some really messy, not as fluid opinions, but it's not something you see in their prior opinions. And then I think he's got this final question, which is, if there are European values, why should national unfair competition law be judging secondary liability? I think that's a real problematic question. All right, final point, as I know I'm like 1 minute, is to compare this with RescueCom. Are there any methodological commonalities that suggest that we're coming to some sort of agreement, consensus on how to approach these? Well, I do think we've fortunately got past the trademark use threshold. We actually are looking at a little bit more systematic effects in a contextual way than simply saying trademark use, therefore defendant wins. which would have prevented getting into these finely sliced distinctions, except, as Stacy knows, in the context of secondary liability. I also like the fact that, like the Rescue-Com Court, they are getting away from whether a use is internal or invisible or within a computer or classifying it like that. I think that was nonsense, and instead are looking at effects. The big issue, I think, two big issues that where they might vary a little bit, but only a little bit, is first of all, how and when to police the confusion analysis. Rescue-Com, because they let the case proceed, you think basically American courts have said, it's all up to trial courts. But we do have evidence, Wentworth's an example, granted only in district court, where summary judgment was granted on the confusion question. It may well be that it's still too early to make a definitive decision on whether there is or should be actionable confusion. But it may be that in 2 years' time, when we have a number of cases saying no one's confused, the courts will be comfortable granting summary judgments and reaching the same conclusion in the United States. Also notice that he limited the confusion inquiry, but he did it, in fact, I think to some extent to ensure a European rule, which makes his unfair competition decision a little bit surprising. Finally, what he does do very well, and I think the US already does it and just needs to do it a little bit more explicitly in the keyword context, he starts talking about the other values that are at play in trademark cases. It's not just that there's no harm. Get over that, defendants. Start talking more affirmatively about the values that are being served by the third-party uses, and I think you get a much richer debate. And one particularly odd one for American eyes that he includes, but I would encourage a debate about, is investment and innovation, as being part of what trademark law is about. We have an absolute aversion in the United States to arguing in terms of investment innovation, because we think that ends up with trademark law being a quasi-patent or copyright law. But once you start understanding and talking about how the use of marks by third parties are important parts of innovation policy, then you end up with a much different, a much richer discussion, and I think that should be part of the US debate as well. So I've gone 5 minutes over, I apologize. Thank you.
Thanks. Okay, I want to start out by saying it's a pleasure to be back here. I started my legal teaching career here and remember all of my colleagues here very fondly, so it's great to see Jackie and Craig and Ray again, and I wanted to thank Jackie for inviting me, and it's great to see new people here like Irina and Cassandra, so it's really a pleasure to be back here. I want to just give you a little context for my talk today. I'm going to talk today about IP as business regulation, and this talk really comes from two different, you may know, like Ray who spoke before, I'm not a trademark scholar. I've taught trademark, and I like to think a lot about trademark issues, but I'm not a trademark scholar. My major area of interest is copyright, in terms of scholarly interest. I think there's a virtue to thinking about IP as a form of business regulation. And I'm going to talk about why I think that's the case. And this basically emerges from two sources. Number one, I'm an anthropologist, so I like to think a lot about context. Number two, I teach securities regulation in business associations, so I tend to think quite a bit about business regulation. And as I teach, this year I've taught IP and securities regulation, and I'll be teaching business associations in the spring, and it struck me more and more that there are a lot of parallels between some things I see going on in intellectual property generally and what I see from a securities regulation perspective. So I'm going to begin by talking about intellectual property as business, IP as a form of business regulation, and one of the things I'm interested in looking at in this project is the extent to which we see consistency in application if we start to think about IP as a form of business regulation. I'm going to start out by drawing attention, and some of this is based obviously on the work of Joseph Liu, who's talked about regulatory copyright and how copyright has extensive regulatory elements. So I'm going to start out by talking about competing visions of IP in the law. We have two different visions of IP, and obviously these aren't mutually exclusive visions of IP. The reason I think these visions matter is that we've talked a lot today. Different people have talked about how we have competing values in different arenas of intellectual property. Free speech might be a value. Innovation might be a value. Competition might be a value. If we tend to think about IP as primarily reflecting a common law vision, we may sort out some of these value conflicts in a different way than if we think about IP as a form of regulation. So when I think about a common law vision of IP, what I'm talking about is you think about laws establishing copyright, some form of property rights, and leave courts to sort out those copyrights. I keep saying copyrights, property rights, excuse me. So you have some property rights that are established by statute, and you leave courts to sort out how do we parse through these property rights in different contexts. Now, if we think about IP from a regulatory vision, that really brings attention to the fact that law regulates the structure of markets for intellectual property. And I want to draw attention to markets for intellectual property because I think we have a lot of contextual evidence today that suggests that the business value of IP has increased significantly in the digital era. And some of this reflects pre-digital era trends. We also see increasingly the development of markets for intellectual property products, both primary markets and secondary markets. And the establishment of secondary markets as the credit crisis teaches us pretty clearly in the mortgage primary markets for mortgages and secondary markets for mortgages, secondary market can profoundly affect primary markets in important ways. So I think there's a virtue to thinking about, if we think about markets for IP, how does that influence how we think about IP more generally? So in terms of context, I want to talk about the significant development of markets for intellectual property and the ways in which we can think about intellectual property as being increasingly regulatory. So 2 steps I'm hoping to get to as part of this talk and stay within my time. Step number 1, I think we need to understand the changing and increasing business value of intellectual property. Secondly, we need to understand the changing nature of markets for intellectual property. As I've written about in a forthcoming piece, intellectual property is increasingly serious business today. Right, I mean, IP is, which is great for us as IP scholars and IP practitioners, right? IP used to be a bit more of a backwater. Now IP is a primary source of value for a broad range of corporations. Trademark and brand value. We see in the patent arena, patents are increasingly valuable, and we're seeing a lot of trading activity connected to patents today. We've seen copyright industries, which have always been important in the United States, but which are a primary mover in the domestic and global economy. So we see a lot of evidence that IP is increasingly an increasingly important source of value for a broad range of businesses today. We also have changing business contexts of intellectual property uses, and the role of information and communications technology is obviously linked to some of these trends in intellectual property. Now, this has a lot of significant implications, right? With the internet and the digital era, increasingly intellectual property is an issue that's part of the lives of everyday citizens. For instance, I think John Turanian from Chapman wrote that article, Infringing Nation, and I think a point from that article that's really important is that copyright, for instance, touches the lives of everyday people in ways that it might not have 30 or 40 years ago. And part of the reason it does that is because of the changing context of internet uses. Now, that has implications for thinking about the competing values in intellectual property. And again, if we think about intellectual property from a regulatory perspective, we may approach some of those competing values in a different way. So some trends to draw attention to: digital era and the growth of ICTs, growth in brand value and equity, and also generalized increased attention to intangibles by a broad range of businesses, and growth of cultural industries. So if we think about intellectual property business and markets, IP assets are increasingly valuable. IP and other intangible assets are key aspects of business and societal wealth today. For instance, if we're thinking about intangible assets, we're thinking about things like information technology, R&D, brand equity, IP, corporate culture, shareholder relations, access to markets, knowledgeable workers. Now, obviously, some of these things aren't IP, but IP is part of a broader business trend in which intangible assets are much more important. In fact, estimates now suggest, and these are old estimates, so the new numbers are probably even more significant, probably more than 10% of US GDP at this point is spent annually on intangibles. So if you look at every $100 invested in stock, in 1982, 62 of those $100 were spent on tangible assets. By 1992, only $38 was spent on tangible assets. So we're seeing a decreasing value of tangible assets in a broad range of corporations today. So this rise of, I think IP is connected to this rise in the importance of intangible assets. And it has great significance, not only from a business perspective, but from the perspective of the broader societal significance of intellectual property. Some places we see this, if we look in copyright, for instance, we have a significantly increasing global and economic significance of the cultural industries. In 1998, Americans spent 120 billion hours and $150 billion on legal forms of entertainment. Now, the illegal numbers are very high today as well. So people are spending a lot of money on intangible goods and services. Many of these incorporate significant ICT innovations. The core copyright industries accounted for 6% of U.S. GDP in 1999, and that share is only increasing over time. I have more recent stats, but for some reason they didn't get in this PowerPoint slide. I apologize. And this is copyright. So let's talk a little bit about trademarks and brands, right? Because that's more relevant to trademarks and domain names, which is sort of the focus of this panel. I'm going to get there, start to talk about domain names pretty soon. So brand value and equity are core sources of company value today. Brands may actually be among the most important of company assets today for a broad range of companies. This is not just technology companies, marketing companies, companies like Coca-Cola, Pepsi. A broad range of companies derive significant value from brand. And if we think about brand value, that sort of reflects what the brand is worth to the company versus brand equity, which reflects perceptions of the brand from a customer perspective. And it's in this sort of conjunction between brand value and brand equity where we have a lot of the issues about uses of trademarks and domain names that are really contested today. I think some other contextual things to draw attention to is that if we think about, we've had a significant growth in advertising generally, even in the pre-digital era. Between 1929 and 2002, in constant dollar terms, for instance, we had a 5-fold increase in U.S. advertising spending. So we have phenomenal increases in advertising more generally. And companies are shifting approaches to branding. Naomi Klein in No Logo, for instance, points out a shift that she sees in the 1980s. And this is how she characterizes the shift. She says successful corporations must primarily produce brands as opposed to products, whereas prior to the 1980s, although it was understood in the corporate world that bolstering one's brand name was important, the primary concern of every solid manufacturer was the production of goods. So we have sort of a profound business shift. And I want to talk about what are the implications of this business shift for our thinking about intellectual property as a form of business regulation that regulates business conduct among business actors, as well as people that might not be actual business actors but might be somehow involved in these intangible goods and services that have now become such a dominant source of value. So one of the things I want to draw attention to, as many people have mentioned, obviously domain name space is different than trademark space, but it may magnify some of these trends with respect to branding and marketing, as well as with respect to potential for simultaneous uses in domain name space. And so domain name geography is significantly different. One thing I want to draw attention to, if we think about advertising, that's a key driver of the internet, obviously. And we also see the internet also enables a lot of bottom-up advertising. So it enables not only increased advertising, but different types of forms of advertising. So guerrilla marketing is much easier. Bottom-up types of marketing are much easier with the internet. Similarly, the internet is a magnificent source of rumors, many of which are false, but which are obviously, for some reason, take a lot of my time and attention. So I try to stay away from blogs and websites that have a lot of rumor because it takes away from my true academic work. So I obviously need to incorporate it more into my academic work. So we also have significant growth in internet revenue and business. So in Q4 2008, and remember these stats are in a time of depression in terms of online advertising growth. Q4 2008, internet advertising sales were $7.13 billion, and in the first half of 2009, they were $10.9 billion. We see the profitability of ad-based models. For instance, YouTube has been largely unprofitable, but in July, Google announced that YouTube has profitability in sight. So it's likely that within the next year, YouTube will actually be profitable on its own. Why? Because of advertising. Because it's been able to effectively leverage advertising online. So that's a profoundly important business phenomenon, the fact that YouTube would be profitable, because I think many people doubted it ever would be profitable. And certainly, there've always been debates about how it could be profitable. And obviously it's sort of demonstrating the way the future of potentially internet ad growth. So I just want to show you these stats. Sorry, this is a little fuzzy, but this just shows us quarterly revenue growth comparison from 2000 to 2008 in internet advertising revenue. And as you can see, there's been a significant upward trend in internet ad revenues that shows that internet ad space is an important source of business value for companies that participate in this space. So thinking more specifically about domain name value, part of what I want to talk about when we think about the internet as a form of business regulation with respect to domain names, when we think about intellectual property as a form of business regulation with respect to domain names, part of what we're talking about is regulation of markets and trading of domain names, right? Because we to some extent with law, we can carve out spaces where trading is not authorized. And in a securities regulation perspective, for instance, we don't allow insider trading. So we penalize people like the Galleon Group who engage in insider trading. We don't permit that. Similarly, there's certain types of domain name trading that because of the way we structure law, we don't permit. And I want to talk, so I think thinking about the market implications of legal structures from an IP perspective can be very important. So domain names have value partly because they're an important source of marketing strategies. Actually, in my experience, when I practiced mostly with startups. And often the first question we would ask before choosing a trademark would be, what does the domain name space look like? Because we were much more concerned about getting a good domain name. We obviously wanted a good trademark too, but if a good trademark didn't have good domain name space, we wouldn't use it. Because we're much more concerned about having a good, especially if you're an internet startup, we're much more concerned about having a good domain name. So to some extent, domain name space can even determine trademark decisions, right? Because the domain name may actually be the most important source of value for a certain range of companies that actually want to do a lot of business on the internet. So domain names are an important part of marketing strategy. They can actually drive trademark decisions and reflect the kind of brand value and brand equity that we talked about. And obviously having a good domain name can facilitate business operations. And I'm thinking about the Glenn Beck domain name that we saw earlier. From a business perspective, that would be a really bad domain name, right? You don't want a domain name that's long. You want something that's easy. You want something that relates to what you see as your core marketing strategies. So, choosing a domain name is a very important business decision that for many companies, not just startups, obviously. And that's one reason a lot of companies are really willing to spend a lot of money if someone else has their domain name, because it's really important from a marketing perspective. So if we think about one of the indications of sort of domain name trading markets are just stats for who makes money from selling domain names. USA Today had an article in 2006 where it talks, domain name trading markets obviously came with the rise of the internet. Because before the internet, there was no need to have domain names. Now, obviously, there were some people, and how we think about these people can very much define how we think they should be regulated, right? There were some people who early on realized there might be some value to domain names. We sometimes call them cyber squatters. But a lot of people make money from trading and marketing domain names. For instance, USA suggests that there are 1,000 to 2,000 individuals in the US who make a living from buying and selling domain names. In 2005, there were sales of almost 6,000 domain names that generated $29 million. And that doubled from 2004, where there were 3,800 domain names that generated $15 million in revenue. So we went from $15 million in revenue in 2004 to $29 million in revenue in 2005, and had a significant growth in the actual number of domains being traded. VCs are now investing in domain name trading businesses. For instance, Highland Capital invested in 2005, Highland Capital invested $20 million in a company called Yes Direct, which is now called Name Media. And that's a domain name holding company with more than 600,000 domain names. Summit Partners has also invested in that same company. So VCs obviously see a business proposition in these markets. Now, some people say this reflects sort of a lottery investment strategy, because there's the sex.com domain name has a really long soap opera-like saga that I'm not really going to go into the background of. But the thing, bottom line numbers, online entrepreneur, you can think of him that way, Gary Kremen, he received $12 to $14 million in cash and stock in 2006 for selling sex.com to Escom, an adult entertainment company. So, with a small investment, you can actually make quite a bit of money by trading in domain names. So the question arises from a legal perspective. Obviously, we have a lot of legal regimes, the UDRP, ACPA. They're intended to target a certain type of domain name trading that is perceived to be perhaps exploitative, free riding on business value established by someone else. But how you see these domain name people who acquire domain names can play a powerful role in thinking about how they should be regulated. For instance, one way to think about these people is as entrepreneurs with an early understanding of future market value. If you see these people as entrepreneurs, obviously this is a market that you want to foster. Because you could argue, for instance, that they might serve an essential arbitrage function in markets, right? You could also argue that they provide a signaling function that might alert others to the value of certain domain names and hasten the development of domain name uses. So you could argue that that's a fundamental part of developing a market for domain names, and that's actually desirable. Now, obviously, we have laws that suggest that that vision is not really how we tend to see a lot of people that acquire domain names, but I think there may be a virtue. The only point I'm making is that by having a certain formulation of law with respect to domain names, we regulate behaviors and make certain kinds of profit illegal. And that we really need to ask ourselves from a broader policy perspective why that's desirable and where do these competing values fall out with respect to that form of regulation. I think we often don't think about IP as a form of regulation in that way, so we may not think about in a broader way how we should deal with these different competing values. So how do we interpret the actions of domain name trading market participants? Are they cyber squatters, for instance? Are they thieves improperly benefiting from investment of others in building trademarks? So I invest in my trademark, and a cyber squatter comes and basically squats on the domain name and then tries to extract profit from me. So it's in this sense, this is illegal profit because we feel strongly that people shouldn't try to extract profits in these ways. So I'm going to skip a couple of slides. One thing to think about as we talk about these changing values, increasingly, IP has always been assets for some companies. Increasingly, IP, intellectual property, is an asset that should be deployed and exploited like any other asset if you're a corporate actor. So in copyright, we see increasingly the rise of pay-per-use models. Dilution rights and trademarks really allow trademark owners to a greater extent to wield trademarks like assets because they could really have something that looks much more like a property right than a traditional trademark right might look. We also may incentivize a lot of strategic uses through IP frameworks that are regulatory but don't necessarily acknowledge the potential for strategic uses of intellectual property. Now, if you think about IP as regulatory policy, you're much more likely to think about ways to attenuate those kind of uses. If you think about IP as much more reflecting a common law sort of vision, you're much less likely to think about those types of strategic uses in a comprehensive way. So there's a virtue sometimes to thinking about intellectual property as regulation in terms of thinking about how you treat competing sociocultural values and competing behaviors in an IP context. So there are a lot of secondary markets for IP trading markets that are developing. Obviously, we have Ocean Tomo in Chicago that's developing liquid trading markets largely based on patent rights. We're seeing a lot of different patent trading strategies. For instance, one of the biggest growth areas in the patent arena is hedge fund litigation funding, right? So you as a hedge fund buy a piece of a patent litigation. All of these secondary markets for intellectual property have potentially profound implications on primary markets, which are the issuance markets for intellectual property. We see copyright securitization that Jackie Lipton actually has written about securitization of intangibles. So we have the seminal Bowie bond deal, right, that was followed by a lot of other securitization deals in the copyright arena. You also see a lot of domain name speculation and trading. So people are trying to trade on and speculate on the potential value of certain types of domain names. So I think we can think of domain name laws surrounding domain names as illustrating the type of business regulation falling within contemporary assumptions about intellectual property. So this is a form of business regulation. There's a virtue to thinking about it as such. I'm out of time, so I'm going to quickly go through my last couple of slides. So IP regulates business relationships. Certain types of activities in business contexts may be deemed unacceptable. They may constitute illegal profits, or we might deem such individuals pursuing such activities may be deemed infringers. And to some extent, intellectual property law can serve to define the scope of legal profits in assets protectable by IP, as well as the scope of legal behaviors surrounding those assets. So I'll end there and just say that if there's a value to thinking about IP from a perspective of illegal profits and prohibited behaviors from a much more regulatory perspective. And just to give you a sense, I think one thing to think about as we go between trademark and copyright, for instance, is do we see consistency in application of IP as regulation? I think there's some areas where we might see some lack of consistency that might shed some light on what's really sort of, what are some underlying trends in intellectual property. One of the things I'm exploring, for instance, is if we look at domain name treatment of businesses versus treatment of businesses in a copyright perspective, sort of copyright theft and domain name speculation, and look to see whether we see consistency from a regulatory perspective of how we treat underlying behaviors in those contexts. So where I'd like to go with this research is thinking about the implications of IP secondary trading markets and the implications of IP as regulation, and I'll end there because I'm out of time. So thank you very much.
All right, we have just about 2 minutes for questions, and then I suggest that the rest of the questions be taken to the lunchtime. So, yes.
Yeah, with respect to the first two presentations, I've been observing a technological change that search engines are moving away from keywords to semantics. So I would buy, for example, overpriced baggage, or flying Greek goddesses. And I'm just wondering how the rules that are evolving today are going to fit into a world where matching is more semantic and less character string matching.
Well, I guess the two responses. One, actually, that's very interesting. I mean, I guess the first response from a trademark owner's perspective is that would be far less problematic, and you would have to think that the number of if you think that you analyze it through some of the metrics that Stacy talks about, substantial non-infringing uses, it's hard to see, for example, oversized baggage or whatever, overpriced baggage, right? It's hard to see a trademark owner having any ability to stop any of that stuff. So.
Would probably be very displeased by having.
Yeah, but I don't think they've got any rights to be able to assert that. So a lot of the rules are probably that the trademark owners are using to assert broader control in advertising would be completely unusable by them, at least in that context. But there's an interesting broader point that comes on this, right? Which is, and I think this is evidenced by how quickly courts and scholars want to come to sort of like some absolute clear rule on a worldwide basis, ideally, as to how we regulate keyword advertising. The nature of online advertising seems to change every 18 months. I mean, I haven't noticed it as much as you have, Carl, but I mean, it seems to me that you could probably pick points in a timeline since 1996, and there are clear shifts. And the problem is that we sometimes want to radically come to a conclusion about a problem that if we just wait a little bit, that problem actually might dissipate. I mean, I think meta tag cases is an example of this, where we were getting all head up about this, 4 or 5 years ago, and I think it's turning out to be probably now largely irrelevant. So I think, in fact, the broader lesson from what you observe is that we should be a little hesitant before trying to reach definitive solutions on forms of advertising that may be passing in time.
Yeah, just one follow-up point. I mean, there are two different ways that you can look at these questions. You can look at the use of the information, whether it's a trademark or some other form of information, by the search engine to generate advertisements, right? You can look at it as the search engine using this mark to push, or this information to push, or you can look at it as the search engine taking in information from its users and trying to achieve a match between those users' interests, whether they be in the trademark or some other thing, and its advertisers, what its advertisers have to offer. And I think this trend illustrates that it's in the best interest of the search engines to try to find the best match possible, and trademarks are among the information that can, but may not, fully come into the mix in making those determinations.
Well, I think overpriced is a subjective term. That's going to put the search engine companies in a much more difficult position when they do semantic matches, because they will be engaging in subjective matching.
A much more difficult position vis-a-vis what?
Subjective decisions is fluid on overpriced.
All right, that's yeah, you're right. But the causes of action that might get triggered about that, I don't think are not trademark infringement because of action. You may be other interesting issues that get raised if you're making representations that are slanderous in some respects about products. But although that doesn't strike me as a very slanderous, I think Louis Vuitton would be quite happy in some respects with being called overpriced as the nature of certain products. But they're not going to be a trademark infringement cause of action. That's going to implicate.
I think we're going to have to continue this informally. Thank you to our speakers. Jackie has a long time.
So, okay, well, I know everyone thinks that I've let this get completely out of hand in terms of time, but all we have to do for the next 15 minutes is actually pick up our lunches across the hall and bring them back here for Jeff's keynote paper. The lunches are literally in the door that I can see directly across there. So if people would like to grab a lunch, come back and we'll start in 15 minutes or so.
Yeah, so let me check.